white smoke pours out of the chimney of the courthouse. It's really kind of amazing. I think the Vatican stole that from us. But we just had white smoke pour out last week. We just have a new magistrate judge, Brian White, in our district. We're very excited about that. There's 12 of us in San Diego, and I think it's the best judicial position. It's the most fun for sure, because we get to have a civil caseload and a criminal caseload. So we get the full spectrum of the law.
Welcome to Between the Briefs, a podcast by Steno. We're here to bring you practical tips, expert insights, and real conversations about the pretrial process, court reporting, and the legal technology shaping the future of litigation. I'm your host, Adrian Seo.
And I'm your host, Joe Stevens. Whether you're an attorney, paralegal, or just curious about how technology is changing the legal industry, we've got something for you. Each episode will break down complex topics, share behind-the-scenes intel, and talk to the people leading innovation in and out of the courtroom. So grab a coffee and let's get into what's happening between the briefs.
Hello and welcome to Between the Briefs, brought to you by Steno. We're your hosts. My name is Adrian Seo.
And I'm your co-host, Joe Stevens.
In this episode, we're excited to welcome Judge Allison Goddard, a U.S. Magistrate Judge from the Southern District of California. Judge Goddard has a distinguished career that spans from representing both corporate defendants and plaintiffs to her current role overseeing federal cases. With a deep commitment to justice and a forward-thinking approach, she's become a respected voice on e-discovery and legal technology issues within the judiciary.
Judge Goddard's journey has been one of remarkable evolution, from her private practice at firms like Cooley and her own firm to her current position in the judiciary. She also frequently shares her insights on the use of AI and other technologies in the legal process, making her a unique and forward-thinking figure in the legal community.
Judge Goddard, welcome to the show. It's great to have you with us here today. How are you?
Thank you. And we could start our Monday off with a little legalese. Before we get started, I'll just make my disclaimer that I'm speaking only for myself and not for the federal judiciary or the U.S. courts. And also that when we talk about AI, I am not a technologist. So take that with a grain of salt. And when I mention any of the tools that I use for AI, I'm not meaning to endorse them in any way. I have a limited amount of bandwidth to experiment with things. So I've kind of picked up on a few things that have been recommended along the way, and I've used what's useful, but I haven't surveyed the market. So I'm not intending to endorse any one product or another.
I'm happy we made that disclaimer. It's very important. So I think that kicks us perfectly into our conversation. So let's start at the beginning, Judge Goddard. What started your interest in the law and really kickstarted your career?
I'm from a big family in Tennessee, and there were no lawyers in my family that I could look to say, oh, there's my uncle, or my father was a lawyer, or my mother was a lawyer. But I always had a strong sense of right and wrong and justice. And I think all of my siblings will tell you I was always pushing against power. So that was something that I always did from a young age. But when I was in college, I was I was definitely interested in law school, but because I didn't have any of those role models, it was hard for me to see myself doing that. Like I didn't have a path forward. So I moved to California to marry my college sweetheart, almost 30 years, and it'll be 30 years in September. And when I moved out here, I was a receptionist at a development company, and my employer did not pay its bills. So it had probably 40 active small claims lawsuits against it. And it had a number of like regular court claims. And so one of the things I got to do was represent the company in small claims court, which was a lot of fun. But it also was a lot of humility because I literally lost every single case that I went to argue. But I did have some interesting experiences along the way. So in that experience, having that experience made me realize that I could do this too. And it also gave me some familiarity with some lawyers who I was able to watch. Some I would emulate down the road and some I wouldn't necessarily emulate. But it gave me the confidence to go ahead and pursue a law degree.
Judge, going from receptionist to a federal judge, can you, first of all, just for our listeners who may not be sort of fully acquainted with the significance of that position, can you talk about, generally speaking, how one becomes a magistrate, federal magistrate, and then specifically your path to getting there?
Sure. And magistrate judges do somewhat different things depending on the district they're in. So when I talk about what I do in the Southern District of California in San Diego, maybe slightly different in other courts. For example, in the Northern District of California, magistrate judges are, quote unquote, on the wheel, which means that cases are assigned to them just like district judges. So they do a lot more trial work than I do, per se. So I'm going to talk about what happens in the Southern District. The magistrate judge process is different from what you hear on the news about the Senate confirmed district judges. Those are, the president nominates district judges, they're confirmed by the Senate, and then they have a lifetime appointment. I am, as a magistrate judge, we are selected by the district judges in our district based on merits. So we go through a process where we submit an application, a panel that's comprised of lawyers and community members vet all of those applicants. They narrow it down to a selection of 5. And then the 5 magistrate judge candidates are interviewed by the district judges, and one is selected. And then white smoke pours out of this, the chimney of the courthouse. It's really kind of amazing. I think the Vatican stole that from us. But we just had white smoke pour out last week. We just have a new magistrate judge, Brian White, in our district. We're very excited about that. There's 12 of us in San Diego, and we do, I think it's the best judicial position. It's the most fun for sure, because we get to have a civil caseload and a criminal caseload. So we get the full spectrum of the law. And we also, in our district, I'm in charge of all discovery issues, and also I try and get every case settled. So as I tell the lawyers when I'm meeting with them in settlement conference, I'll give them a very candid assessment of their case. And then I'll deliver the good news that I'm not actually making the call, because the district judge is like the mom or the dad, but I'm the fun uncle. I'm the one they can tell all their secrets to. They can tell me how they're really feeling because I'm trying to get this case settled. So I actually get to talk to people, which federal judges, a lot of times in the district judge, you see them at a hearing or at a bar event, but there's no in between. But I have constant conversations with lawyers, and that to me is one of the best parts of the job, lawyers and their clients.
That's fascinating. And I'm curious, was it a big shift to go from the private sector into the public sector in the way that go to trial, practice law?
Well, financially, there's a big shift.
That's the truth.
Although it was just different to go be in a private practice and then all of a sudden, go to, and I had not had a direct deposit paycheck when I became a judge for 15 years. So that was really different. I wasn't used to working for someone else. And we're kind of like our own little hives around here. So I don't really have necessarily per se a boss, but I am working in a structure. And before that, it was pretty much just me and my law partner. So that's a big shift too in the way it works. People, when I first got on the bench, they would say, "How is your stress level? It must be so stressful to be a judge." And I would say it's like, I don't know, kindergarten, because I don't have the stress of being on the receiving end of the nasty emails about a discovery dispute. Or when I talk to one of your clients in a settlement conference and I give them the bad news that I think they don't have a very good case, I am doing that. They see me, I get automatic credibility. I get from a position of respect. And I didn't always feel it as a lawyer. I'm not sure I deserve it as a judge, but I try my best. But it's nice. And I feel like I'll explain to people, especially in the settlement context, I'll say, look, I wouldn't be doing a good job as a judge if I just came in and told you how great your case was if I didn't believe that. Like, it's my job to give you a real sober assessment of what's going to happen in court. And sometimes that means that I don't have good news for you. I think that you need to either get out of the case or find a way to do this or that. But I don't have to live with that afterwards. I don't have to then ask that client to pay my bill. I just think there's a lot of stress involved with legal practice, because I don't have to carry my clients' issues with me in the same way that a lawyer does. That, to me, the best lawyers do. They have a lot of empathy with their clients. And it's not that I don't have empathy. It's just that my empathy, my relationship ends when the settlement conference is over. Although I'll tell you, in settlement discussions, I really don't stop. I mean, when the conference is over, I keep going. I do, there's many people who stay close to mind, and I'll be watching the case, and then have the chance to talk to them later. Maybe they're more ready to be open to settlement. So that never really ends, but that's a big difference between being a judge and being a lawyer. The stress is just much, much lower.
It's so fascinating. I live and practice and teach at a law school in West Texas, and I've spent the last 5 years in rural public defense in Texas. So that level of empathy, and then the waning, the difficulty that comes, just the tax that sometimes if you do it the right way, the fact that it is sort of emotionally draining, and then the willingness, I imagine, to then switch over to a career where, yes, you might be making a little bit less money, but the peace of mind or the calmness or like the emotional well-being is being prioritized. But I want to ask you this question. You talked about this sense of justice or right from wrong early on growing up in Tennessee and pushing back on the system. Was it difficult for you to then sort of become a part of, in a way, a part of the system, right? You're no longer an advocate that way.
Yeah, so when I had been working, I went from the receptionist at the startup at the developer to working for a startup company, and I have various positions there. And so I worked for about 4 years before I started law school. And one of the things I was doing was kind of contract administration, and that was really where I was working with a lot of lawyers at big law firms, and they were really smart people, but I kind of felt like my head was sore at the top because for getting my head patted for having some cute ideas. And I thought, I can do that. I can do what they're doing. And so when I got out of law school, what was familiar to me was that corporate practice. My husband actually, when one of the only kind of requests he made as I started on my journey in the law, because we were married for 2 years, and I was like, I think I want to just quit my job and go to law school. And he was very supportive at every step. But he did say, I I really want you to think twice before you go into criminal law or family law, because it's very difficult, as you know, Joe, to separate yourself from your clients. And I think if you're going to have a career in one of those areas, you have to learn to do that successfully. So it's a real trick to keep the empathy alive, but to be able to turn it off so that you can have your own life. Because if you can't figure that out, it's not going to work. You're just going to burn out. So when I went, when I left, when I graduated from law school, I had an offer at Cooley, and was a great firm. I would never have left Cooley to go to a different big firm, but I thought I'll give it a try. Right, this is what I know. It's really good money. If I don't like it, then I just won't stay. And so I learned so much in the 4 years I was at Cooley about being a good writer, and even about like that professionalism, like how you address clients, how you handle clients. But I didn't learn about how to be in the courtroom. And so what pushed me to leave Cooley was not any issue with Cooley, because I really felt like it was such a great firm to work at. They were a lifestyle firm, and they walked the talk, where that was concerned. What I really needed to do was I needed to get in the courtroom. I left Cooley when my oldest child was 9 months old, and at that point, it was a kind of a turning point. Like, okay, I have a baby now. If I'm going to spend any time away from that child, it should be time that I feel like I'm getting the most out of. So that's when I took a jump off and kind of started my own firm with a partner from Cooley. Cooley didn't let us go very far. We actually they rented space to us, so we used to joke that we were like living at our parents' house, but without having to follow the rules. Um, and we got a lot of overflow work from them. So I continued at that firm to do kind of corporate defense. Um, and I just got so many more opportunities because I was handling smaller cases. I don't feel like I had to compromise financially in order to have a better practice for me to develop as a lawyer. And then what happened after Cooley, after Jasco Goddard, was the 2008 recession. I don't know if other lawyers felt this, but it was like a 2-year lag for smaller law firms. Cooley all of a sudden was giving us a lot of referral work, but all of a sudden they were holding on to cases. And then they had more people who had left Cooley, so they had more of these kind of like ancillary firms to feed. And so our business just absolutely dropped. By that point, My husband had decided to leave his job in software development and become a public school teacher. So he was not working. It's 2010. I call it the year of Job for me. He wasn't working. We had a property in Tennessee that got destroyed by a massive flood that we had to pay for out of pocket. And then I had my oldest child that had some really serious medical issues that have gratefully since resolved. So all of a sudden, and then now my law firm's falling apart. So what am I going to do? So I had a friend come to me and say, I'm doing plaintiff's work. I need your help. Can you please come do this with me? And that's how I shifted from corporate defense to being total consumer law. Everything about my career has been serendipitous about where I found myself and being open to what paths were kind of in front of me. And that's a really good example. That was never in the cards. If you'd asked me 6 months before I started working with Patterson Law Group, did you really have a drive to work on the plaintiff side? I would say no. But I'll tell you, it was some of the most satisfying and rewarding work. And I got a taste of some of what you get from the client relationship on the criminal defense side, or on the prosecution side when you work with the victim, which is I was representing people who have been fired. Being fired from your job is one of the most emotionally devastating things. From the person who was out there, I had a conversation with the guy who was running the fryer at Kentucky Fried Chicken, to a high-powered executive who is making 7 figures. Being fired is one of the most emotionally devastating things that can happen to you. And being able to take the call and talk to all these people, 99 out of 100, I would tell them, a lot of things happen that aren't fair, but that doesn't make them unlawful. And I don't think you have a case. And they would say to me, I just really thank you for taking my call. I feel so much better since I talked to you. That's like such a gift to be, and to make your money that way, is that's how you make your living. Like, how lucky can you get, So that was I think it was a long-winded answer. I can't remember what the question was.
No,
Uh,
you got it. That's
there you go. I'll just make my
yeah.
own questions up as I go.
No, it's great. Love hearing your story. It's very impactful. And like you mentioned, it's very serendipitous. I'm sure you learned a lot of lessons along the way. So when it comes to being a magistrate judge, you talked about how you're chasing the settlement, right? You know, it's like in good terms, you want the settlement to happen. What tips or lessons have you learned to make that settlement more likely to happen and really fulfill your position as a judge?
The number one thing I try and do is establish some sort of an authentic relationship with the client, and not to separate them from the lawyer, but you need them to believe that you are have their interests at heart too. You're not advocating for them, but they need to feel heard and listened to. So on the plaintiff side, particularly if I'll do this on either side. If I have a client who's an individual, let's say, I'll tell them, Mr. Smith, I just want to explain to you that I'm going to be speaking to your lawyer more than I am to you today, and I want you to understand why that is. It's because you hired your lawyer because he knows how the law and the facts work together. I don't want you to get the sense that what you have to say is not important. It's the exact opposite. You're the only person in the room who can interrupt me at will, because this is your case. You're the one who was injured. This is your life. And if you think we're talking about past anything, or we're not focused on what's important to you, you need to stop us and let us know. And I think that's really important. It's all these things. I don't just do it to get the settlement, but I'm also doing it for myself, because there's it's a really nice thing to see the reaction of people's faces when they feel heard, when they feel like you've recognized what's happened to them. I haven't told them that they get money. I haven't told them they're going to win. I might have to tell them in the next breath that things happen that are unfair, but that doesn't make them illegal and you don't have much of a claim. But at least it clicks with them, right? And then on the corporate side, when you have a corporate client, it's really helpful that I had all those years of experience at Cooley and at my own firm, because I can tell them, I'll tell the CEO whose company is in Florida, I'll say, hey, now you know what it's like to have a company in California, right? We've got different wage and hour laws here than you do in Florida. And I just try and make that connection with them. And you can tell they appreciate it too, because, you feel you recognize their pain. This isn't what's making their company money. It's a hassle. They don't believe it has any credibility. I haven't told them that I think that they're wrong. I've just told them that I understand what it's like to be in their position right now. And again, you get that psychological satisfaction of making that connection on a human level, which is pretty cool. That's one of the most important things I think you can do when you're trying to get things settled.
Judge, you're talking about things that and behaviors and sort of just like wonderful human principles, right? Like what the value of listening and making someone feel truly heard. When you let's pivot away from you as a judge, but when you're now dealing with advocates on either side, what are practices like that that you think are really sort of healthy practices in a courtroom, and what are some pet peeves that you have of advocates and what they do or what they should do better or things like that?
What I like in a settlement conference is the lawyers who I don't mind if a lawyer pushes back at me. I'm very straightforward and I'll just come out and a lot of times I think you can kind of see it. Sometimes you feel like maybe I pushed a little too far, right? I got to let them push back a little bit. I'll pull them a little bit back towards me. But I'll be really straightforward about the case and I'll come in and I'll say, I read your brief and I understand that you are this, and this, but like, how are you going to get this into evidence? How are you going to get past summary judgment when there's a dispute about this? And the lawyers who fight everything lose credibility. That doesn't mean they have to concede anything to me. But what they can say is, Your Honor, we recognize that's going to be an issue, but, you know, or it just to ignore, like, as much as is important for you get more out of people when you acknowledge them instead of just fighting every step. And so I think it's really important. And when I have those lawyers who I can tell sometimes you can see it in their client, like are they fighting with the judge a little too much? Um, I'll recognize them. I'll say, look, I appreciate that I have pushed you hard, but you've given it right back to me, and I don't mind that at all. And but there's a difference between doing that and feeling like you're closed-minded. Like if you come into a settlement conference and you declare early days, this case isn't going to settle, then that's going to be a problem for you with me. And then the other thing is, it's not helpful to be personal about the other side. You can tell people who have maybe they've only done one type of law or represented one type of client, and over time they've had to, as part of that, become true believers that the other side must always be wrong or evil. And it's just not like that. That's one thing about that I learned at Cooley. I learned from some great partners, and they never took the approach that our client is always right. They took the approach that we need to figure out what the smart business decision is to recommend to our client. And we have to acknowledge that sometimes your client's wrong, and you need to be upfront with them about that. And I see a lot of lawyers who don't have that ability to speak to their clients in that way, maybe a lack of confidence. There's that middle band between when you're the junior attorney getting to sit in and watch and the partner who has the control. I call it the mid-level associate. I call it the baby rattlesnake phase, because I don't even know if this is true, but it's the myth you hear that baby rattlesnakes have all of the venom, but none of the ability to regulate it. And that's kind of like in that band of lawyers where you haven't had enough experience to recognize what's important and give on what's not, but like focus on what is. And when that happens, my clerks will tell you, I'll come back, I'll say, oh, I got a baby rattlesnake. And I try, you do your best to get through it, and you realize that they're going to have to learn as they go. But you also you recognize that you don't hold it against them. You think, well, I hope I get to see you again in a few years when you're a little more polished. But being honest with yourself and your client about the case is really important for settlement.
Now, Judge, I would love to get your take on how AI is really changing the judiciary process. Have you seen attorneys using it to help their cases? Have you been using it yourself? I would love your thoughts on that.
If attorneys have been using it, I haven't seen it visibly, which is good, because I think the only way you see it is really through hallucinations that come into brief. So I haven't had that happen, and I'm very grateful for that. I'm glad. That doesn't mean that I hope they're using it. That's what I would say. I hope they're using it. And if they're using it in a way that's seamless to me, that's even better. I use it. I use it as I think that probably the best way to describe it for me is like as a thought partner. It's my goal this year to I haven't tried agentic tools with AI. I think I'm too much of a control freak. But I need to try it just to understand it a little bit better. But in the course of the day, I will have Claude open all the time. I ask it questions. I'll ask for it's like to bounce ideas off of. I speak a lot, so I'll use it to help me with my speaking presentations. I'll use it to help me think about what are maybe take myself outside about what the audience might be wanting to hear, or because I've got, my own agenda for my own experience, but what are the things that other people want to hear? And then I use it for writing all the time, like getting some ideas on analogies. Am I saying this clearly enough? And then we have some trials going on right now with Lexis and Westlaw for protege and co-counsel. And I think for judges, one of the most amazing tools is I first use Notebook for this, but you can create your own database and some of these legal based tools. Um, I do a lot of Social Security appeals, which are as exciting as they sound. I don't mind them, but they're highly technical, very fact based. And the law is there's like a case for everything, and there's a case for the person who's schizophrenic and diabetic, right? And you want to find the most applicable law from the Ninth Circuit when you're writing your order. And so one of the things that I'd done is I'd created, but on all those platforms, to try it out, I've created kind of my own database of my own Social Security orders. Because you never want to cut and paste from another judge's order, but you can cut and paste from your own orders all day. And that makes it much more efficient. And so I've created my own little model, and I prompt against that. And so I can pull up the cases I've already done. I've got a bank of about 50 of the orders I've already done. It can do probably about 35% of the draft for me based on my prior work, which is a huge time saver. And it's not doing any of the thinking for me. It's just helping filter the information in a way that makes it much more efficient.
Judge, if you mentioned you hope lawyers are using it. I'm wondering if in what way? I mean, are you saying that from the sort of the perspective of if you were still in private practice, this is how I would be using it? Or what ways do you think it would be beneficial, I guess is the first question. And secondarily, if they do use it, I don't know if there's any disclosure requirements in your court or in the Southern District out there, but should there be?
Anti-standing orders or disclosure requirements for AI, because I think that the people who are going to not use AI properly and keep a human in the loop are also there's no Venn diagram with an overlap between people who will read that rule and follow it and people who will use AI tools without keeping a human in the loop. They don't overlap. You're reaching the wrong audience. The people who are really diligent about the rules are the people who would always check, right? So and then what happens with the disclosure is your client going to let you file a brief that says in the caption page, used unverified sources? I think one court required people to disclose that they used unverified sources. Like, no, your client, so you're not going to use it. I absolutely want people to be using it responsibly and think of AI as a tool. There's so many different ways you can be a better writer. Maybe you can make your brief shorter. That's another thing. Just going to throw that out there. You could use them to prepare for oral argument, right? You could use them. I've seen lawyers use it very effectively where they upload the briefs and they ask the app, either ChatGPT, Claude, what have you, give me 10 questions I might get from the judge on this. And I've done it with a old motion I had before I got on the bench. I uploaded all the motions, the briefs, and then I had a transcript from the hearing. And I asked it for 5 questions that the judge might ask me at the hearing. And then I compared those to the transcript, and it asked 4 out of the 5. It nailed 4 out of the 5. I mean, that's going to make you a better lawyer. And that's easy, right? And imagine all of a sudden, I went from huge law firm to 2-person firms, right? I really missed having the people down the hall who I could bounce ideas off of. You didn't go to a appellate argument as a coolie lawyer without being mooted in some way by some of your colleagues. And then all of a sudden you're finding yourself, you're basically like effectively a sole practitioner. Who are you going to moot with, right? And it's really helpful. One of the ways I wish I had it when I was a lawyer is I wish I had it for deposition prep, because I wouldn't ask it to give me questions that I might ask the other side. I would ask it to give me questions that my client might get so I could better prepare them for the deposition. Because even the best lawyer, once you're immersed in the facts, you're trying to advocate for your client, you really can't it's too hard to change your mindset to what the other side might be thinking. But there's the other side right there. It's in Claude, it's in ChatGPT. You can just ask it to be the other side for you. And it's like one of the best devil's advocates you could ever imagine. I think if you're going into deposition these days and you've got a client that you're defending and you haven't at least done that, you can do that for free. And it's going to become kind of malpractice not to be prepared in that way,
That is very true. Very true. And so it's so important. You just got to come prepared overall, and it basically gives you all the ammunition to become the best lawyer you can be in court.
Yeah, and I suggest to other judges, like if you have a long order, you should before you finish it, ask it to summarize it. Put it up in there, ask it to summarize it. Is the summary accurate? Sure, that might be a problem with the AI tool, but what may be more difficult, what maybe the real problem is whether you were clear from the get-go. But then also take the summary and consider putting that at the very beginning of your order or at the very end, or tweaking a little bit to make sure, a lot of times we'll have orders, let's say like a class certification order, and there's a lot, like the parties have asked the judge to decide a lot. There's multiple claims, there's multiple there's a number of subclasses, and sometimes you'll read a motion to dismiss the order and you're like, I'm not sure what's left and it's not clear. So and by the time you get finished with the order, maybe the clerk was just so done that they just don't have the bandwidth to do it. So throw it into one of these tools, have it tell you, do you agree? If you don't agree, then you need to go back and rethink, maybe your order isn't as clear. But if you do agree, then put it right in there. These are the claims that are remaining, and these are the claims that are dismissed. And I think that it's a small and subtle way to build credibility and confidence with the public. If you can read a judicial opinion and it makes sense to you, I think that's better. That's a good goal.
On the flip side of this, because again, as a practitioner who uses it as well, I see all of the benefit to it, especially when you're talking about like access to justice issues. It's a democratizer in so many ways. But what what in your mind do we lose? Is there any valuable skill set that's not being polished as much anymore? Like what falls off because of this tool that replaces so many things?
So I'm much more of an optimist than I think a lot of people. I mentioned my husband is a high school teacher, and I also teach a class in high school. And that's how I even knew that ChatGPT was around. One of my students used it for an essay, and I was like, wow, it was a pretty good essay. And then one of the other students, he's like, that's because he uses ChatGPT, Judge. So, uh, but one of my husband's colleagues said, and I think this is really true, about the fear about, are people going to know how to write? Are they going to know how to do things? He is an English teacher, and he said, we are all like math teachers in the 1970s when the scientific calculator came out. And everyone swore that no one would learn math because this calculator did so much of the work, right? You don't have to memorize the formulas or write them down anymore or walk through all the steps. And what we found is that math still exists as a field, right? It's still a pretty important discipline. And we've just learned to do math in a different way. And we're not spending as much of our time doing math, doing some of the stuff that's more rote that the calculator can do. So I think we need to think about that. I worry about younger lawyers and how are they going to get up to speed and learn about the ins and outs of law, right? And get that experience, right? If they're a lot of their interactions are not through a partner sitting down with them and saying, here's what I think you should change about this brief, but getting it from like an AI tool, for example. So, but we have ways to counter that, right? We can still focus on mentorship. I'm much less concerned about how AI's proliferation on training lawyers. I think we're all going to learn how to write a different way than I am concerned about the shift to remote work for young lawyers and how hard it is to get any sort of mentoring or training that way. Uh, but I think one of the things that I think we really want to make sure is is how we're focus on how we train younger lawyers. And then this may be an unusual thing to worry about. I worry about when I talk to clerks in our court and other judges. One of the things I put on I have like a slide about the list of things that kind of worry me about AI is really complacency and then becoming over reliant on it. So that's why constant reminding you have to keep a human in the loop, because it's just going to get better and better at these functions. And you always have to step back and say, that's just a tool. I'm still in charge. I'm still the lawyer. And my kids went to a Waldorf school. And one of the big things about Waldorf is they don't use iPads in the classroom, and you don't use computers till you're like a junior in high school. But in 8th grade, they learn about the computer, and they learn about it by taking it apart and putting it back together. And it's a really important lesson that the computer is a tool. It's not the brain. And that's we have to continue to remind ourselves that the AI applications are tools. We still need to have our own agency in how we use them and how we view the information, the outputs that come out of them.
I always say, if you really want to understand the technology, just understand how it's made to begin with, and that way you get a good understanding from the foundation to where it goes.
I think it's really important. I don't think we do enough of it. I feel like there should be some sort of a class in school where we learn something like that, right? Or just have that experience.
Now, Judge, I would love to know what do you feel is next for you, right? You've gone to the judge level now, so where would you like to what would you like to achieve next?
So I'm really having fun with bringing AI to other judges. And I've been doing that quite a bit by speaking around the country and training people and showing them how I use it. The next level is, letting judges around the world, know about that. I've spoken in Uzbekistan to judges there about rule of law, judicial independence. I would love to do more of that type of work. And I'll be speaking to some judges in Central Asia next week on things like that and how we're using AI and sharing information about the work that we're doing here and how it can help them in their country. That's really fascinating to me. But just continuing to kind of be a student and a teacher at the same time is really a gift for me.
Judge, one question that I'm interested to know, the role of the judiciary in American society has changed so much and seems to be perpetually in flux or shifting, I suppose. I don't know the right word to use. In the time that you've been on the bench, what have you seen? I mean, do you see when you go to a place like Uzbekistan and talk about rule of law, or do you see the perception of the American judiciary reflected back to you in a way that's different now than it was 5, 6 years ago? Or how is that evolution sort of taking root? And I don't know, I'm just interested in your thoughts on this.
It feels really good to be like in Uzbekistan because they hold us in very high esteem, the judges do. And actually it's kind of an interesting exercise we did there in 2023. Uzbekistan amended their constitution to add effectively our Fourth Amendment, the principles of the Fourth Amendment, that you have to have probable cause for search and seizure, for arrest, and that it really gave defendants rights they never had in the criminal courts to present evidence, to make arguments. And so if you can imagine like just going over there, and the government had like a 99.99% conviction rate before this change. And now imagine being a defense lawyer where your job was to just walk in and be here like a potted plant. And now you have a role as an advocate. Like to be on the ground and talk to judges about that transformation was just amazing. And they recognize that the ability to having a system like that where people feel like they have a voice, where they feel like it's fair, builds public confidence in the judiciary. I worry, as every judge should. I mean, the Gallup poll came out, I think, last year, and the numbers were terrible about public confidence in the judiciary. So I think about that all the time. I don't necessarily have any easy answers, but I do think that transparency, authenticity, writing opinions that are approachable, that you can, I always think if you need to have something in an order that basically could be like a tweet or a skeet or your message your 3-line message to the world about what this means, that is something that makes the judiciary more real and present to everyday people. The law is in the news constantly, which I think will help in the long run. We're just at a really challenging period of time. I think that the courts are being challenged, but I do think we're going to come out on top. I do think people appreciate the rule of law, and I do think they recognize how important it is. And I think it's just been always in the background for so many years, and now we're going to feel it a little more viscerally.
It's a great take, and I can definitely see us always coming out on top on that, especially with more education on how just it all functions to begin with.
Well, I think we're seeing in real time what the courts do. I think we're seeing in real time, like we're getting a sense of what due process means in real time. It's becoming part of people's vocabulary, which I think is really good. And I've been really heartened by some of the survey data that's come out that shows that people care about due process. I think that's really important. I saw a T-shirt the other day. It says "due process freak," and I think I need to get one for myself. Um, because
That's
it's like
amazing.
it's really wonderful to hear that people are getting it and understanding it and supporting it. That's an amazing. That's good. That's something that really pumps my tires. So.
All right. Well, I think this leads us perfectly to our next question, which we ask at the end of our show. And that is, what is your hottest take on the industry right now?
All right. So I'm not known for my hot takes. I'm kind of a nerd. And so I had to ask my bestie what he or she thought. I mean, I don't know what they thought. Claude.ai to Claude.
Oh, wow. Here we go.
So, um, so it was really kind of negative. I think he's having the case of the Mondays today. He said the legal industry is massively overcomplicating itself into irrelevance. I don't know that I necessarily agree with that, but I think the point was you should focus on Claude's point was in the legal industry, people need to start focusing on specialties because AI is going to do the simpler stuff. So you need to be focused on kind of have a little bit more of a path. Um, I think, and this is kind of like broader than the legal industry, but I guess my hottest take is the most important quality that successful people are going to have over the next 10 to 20 years is authenticity. And I think that we're going to have to find a way to be our real selves. I think lawyers, which also means that we're going to have to work on being better selves. Because if you've got to be your real self, you want to be a little bit better. But I think that I saw on a social media app the other day, I saw Mark Cuban posted something about what he thinks is the development of AI is face-to-face is going to become even more and more relevant. And I think that goes hand in hand with the need to be authentic. And I think we're seeing that now with our political leaders. People want to hear from someone and they want it to be real. I think it's a real optimistic take. I think it's something to look forward to. I feel like we're in the middle of a lot of chaos right now in our society, but I also think that's because it's a part of the natural progression of what happens when technology presents us with this massive revolution of data and information and now technical capability for how we might sort through all that. So I guess my hottest take would be if you want to be a good lawyer, if you want to be successful, you need to be thinking about how you focus your practice on being an authentic person and being someone who's real. And I think empathy is way underrated, but it's obviously been a huge part of my success at every step of the way. But not just success is defined by money or like trial victories, success by feeling like I wake up every day and think I'm so lucky to have this job. That's success, right? So my hottest take is to be authentic.
That was a fantastic hot take. Love that you prompted AI to ask it its hot take as well. We haven't had that yet, and I feel like it actually showed up for us.
That's a good example of how I use it as a thought partner, right?
Exactly. I love it, Judge. That I will say that is that we've had, I don't know how many episodes we've had at this point, but that is hands down my favorite hot take that we have had.
That's funny. Well, I think you're paid to be nice to me, so that was fine.
No, no, and I know, and I don't even practice in the Southern District.
Yeah, and assuming that you went in and that you were diving into your authentic self when you said that, so I'm going to take it for everything.
Well, that works well.
Thank you to our audience for tuning into Between the Briefs, brought to you by Steno. A special thanks to our guest, Judge Allison Goddard, for sharing her valuable insights in the intersection of law, technology, and the evolving role of the judiciary. And of course, a big thanks to our co-host, Joe Stevens, for another great discussion.
Yes, Adrian, thank you. I could talk about empathy and authenticity all day long. I think it's wonderful. So thank you, Judge. Be sure to subscribe so you never miss an episode, and stay tuned for more thought-provoking discussions at the intersection of law, technology, and innovation. We'll see you next time.
Up next on Between the Briefs.
Well, you can't serve anybody if you're starving. Like, if you can't feed your family, how can you help your clients?
Stay tuned for the full interview coming to you soon. Between the Briefs is brought to you by Steno. To find out more about Steno and how we combine exceptional court reporting and litigation support services to deliver a superior litigation experience, visit steno.com. That's STENO.com. And then make sure to search for Between the Briefs in Apple Podcasts, Spotify, or anywhere else you get your podcasts, and click subscribe so you don't miss any future episodes. On behalf of the team here at Steno, thanks for listening.